What's up, everybody? Another week here, another month. It's May 1st, and we have some stuff to talk about in the Brian Koberger case. As we all know, the preliminary hearing is set for the end of June, but just recently, this weekend on Twitter, a bunch of people tagged me in some posts about a hearing coming on May 25th, which is interesting. And I think it's worth talking about because when you've set the preliminary hearing and nothing else is really supposed to happen in front of the court until then, why would we need to have a hearing? And I think there's a bunch of plausible explanations for this. We will go through some of the options, not all of the options, but some of the options, some of which are not that exciting and not that big of a deal, all the way to and all the way until the most potentially surprising action, which could get rid of the preliminary hearing altogether. So we're going to talk through a bunch of different options. I'm going to answer your questions as usual about this and the surrounding subjects. Make sure you hit that like button if you haven't already and hit that subscribe button. We're almost at 225,000 subscribers. We're slowly climbing to 250. So if you haven't subscribed yet, please take a second and subscribe. We have also been seeing some stuff happen in the Letitia Stalk case. A lot of you asking me about a mental health expert that's testified recently. And we are going to talk about that this week. Lori Vallow stuff is still happening with that case. So we will talk some Lori Vallow this week as well. And a lot of things just happening. So make sure you're following us on Instagram and Twitter as well. At Tragos Law right here is our handle. That's why it's there. So you can send me stuff on other cases, clips from other cases, articles from other cases, because once the Stalk and Vallow trials conclude, we will be looking for a couple of new cases to follow along with the Courtney Clenny case. And of course, Sarah Boone and Brian Koberger. Lots of content and things happening. And it seems like it will always be happening, right? I mean, you think when the Johnny Depp case ends that, maybe things will slow down, maybe things will be different, but no, it is one case after the other, whether it's criminal, whether it's civil, and, stuff just keeps happening in our country that I think is worth talking about and is definitely worth learning from. And as long as you all are interested in it, I will be talking about it and we will be talking about it together. Yes, I forgot. We did do a podcast that posted today. Chelsea reminded me. It was on gag orders. So we talk about the gag order in the Brian Koberger case. We compare it to gag orders in some other very high profile cases because I had so many questions about there's a certain Instagram influencer who has a very, very big following who may or may not have tagged me in something recently that reached out and she had some questions. And I think this was from her, actually. I'm not positive, but I think she asked if these gag orders are, or this might've been from Sleuthy. I'm not positive. I'm getting all these questions mixed up in my DMs. If this was the only case we've ever seen a gag order like this on, and what are other cases that have gag orders like this? And are they trying to hide something in this Brian Koberger case? And the answer to that is no. And we really dig into what gag orders are, what the purpose of them are, and what the purpose of them is, and what other cases that you have heard of had gag orders very similar and some even more restrictive than this case. So check out our podcasts on iTunes, SoundCloud, Spotify, wherever you listen to podcasts. It's called the Lawyer You Know podcast. All right. So let's get to this hearing, okay? And first, let's answer this question. Oh, dang it. Somebody just blew it. Look, it just blew the whole video. Rodina, Brian Etten just posted that the hearing is related to the gag order. That was going to be on my list. So we will talk about this and some other things that it could be. Okay, some other things that it could be. But remind me to come back to that, Rodina, if I don't. Alrighty. So what's the purpose of a hearing? And that makes sense if it is the gag order. You don't have a hearing at this juncture of the case, or really ever in the case, unless two sides have a disagreement and the judge needs to make a call. So if, as we've seen in this case, a motion has been filed, if a judge is going to sign the order on it or both sides agree, the judge will sign the order on it. In this case, multiple times, the judge has signed the order the same day the motion is filed or a notice is filed. So that's not surprising at all. If they agree, the judge will just sign the order and we'll be able to continue on doing business as usual. But if two sides agree whether it's the defense and the prosecution, or whether it is a third party interpleader and the prosecution, then you need to have a hearing. And the judge is going to listen and make a ruling. Okay? So, option number one. Okay, and this was the most likely option, and now it's been reported by Brian Hinton as what's actually going on. I have not seen any of those reports. I have not been on Twitter or anything today. It's been a full day of meetings. Nobody has to say sorry. I was just kidding with you, Radina. So option number one, because we've been seeing it be heavily litigated already and argued about, is this gag order, which is perfect timing for us to have that podcast episode. So make sure you check that out. So that's the first and most obvious option, because if you listen to our other videos on the gag order and what the Supreme Court in Idaho did regarding that gag order, they basically told the media organizations that you may have a pretty good argument, but you did not follow the proper procedures. The proper procedure would be to first take it up with the magistrate, take it up with the court that you're dealing with this gag order in, which would be the lower courts in this situation, with the magistrate that actually signed and put the gag order in place, had the hearing with the lawyers back in chambers, edited the gag order, and filed the amended gag order. That is the first spot you take over your issues with the gag order and ask her to either amend it again, get rid of it, make it less vague, make it less restrictive, allow you to do your job as the media and tell the public and protect your freedom of speech and freedom of the press. That is the first place you go. So if we're making a guess and you're putting bets down, this is probably the best bet as to what that May 25th hearing is. Now, if I was the media, I might be a little bit frustrated that it's going to take a full month basically for us to get in front of this court. But if you're the court or the defense or the prosecution, which are with the court in this situation, all three of those parties are in agreement, the court, the defense, and the prosecution, that they want this gag order in place, which is what makes it difficult for the media on this side to really fight against it. But if all of them are in unison and May 25th is the date that they are giving, then as the media company, at least you can say, well, at least this is before the preliminary hearing. At least this is before the first big thing that's going to happen in this case. So that's the most likely scenario as to what this hearing is going to be on May 25th. Now, some other very obvious ones are discovery disputes, but it's not normal discovery because it's a preliminary hearing and not all the normal discovery rules apply. But if one side or the other thinks that something should be turned over, they can file a motion with the court and have a hearing to compel that, or to force the other side to give it over, or to invoke some kind of protection with a protective order or privilege or confidential documents. That can be a reason for a hearing like this, which might not be a big deal at all, or might be a very big deal, because discovery is very broad. Anything that's reasonably likely to lead to discoverable material. But it could also be, because we have so many different interesting scenarios coming up, there could also be a motion that has to do with Bethany Funk and what's going on in Nevada. Because if you read the motions and the orders in that case, that's all being done in a Nevada court. So something may have been filed in this court, but if you check the docket, we don't see anything filed, which is why this is less likely than something to do with the media. But something that would equate what the Nevada court has done, just taking notice of the stipulation that they are going to interview her and she is not going to be called as a witness at the preliminary hearing. Because as we sit right now, if a Nevada court says, okay, we recognize that stipulation, but in Idaho, they say, well, we didn't say that they couldn't call her for this preliminary hearing, and they want to call her and subpoena her again for the preliminary hearing, then maybe it could happen. Future, absolutely. What I'm saying is we don't know. But I had questions. Basically, a lot of these options came from a lot of your questions. So I want to give you the answer. If it comes out to be one of these things, you can kind of have an idea of where we're going. And that's kind of the purpose of this video. Okay. Because what I actually think the best thing about having real life cases to talk about is not even necessarily trying to guess the outcome or what's going to happen next about these cases, but it's to use these cases to learn how the process works. And sometimes when you have a question about a case, and again, I'm not going to say, oh, this hearing means I'll save it to the end. I'll save it till the end. I'm not saying that's what's going to happen. I'm just saying here's what it would look like if any of these motions were actually taken to hearing. That's, I think, what's important about this. Is because we can learn. This question is an opportunity for us to learn. And I saw a lot of questions flying around on Twitter and Instagram about it. So I thought it'd be an interesting conversation. Okay. So it could have to do with something like that. And then I also had the rule here in Idaho, which I think is interesting. Let's pull it up here. We can take a look at it together. That most people, when talking about depositions, think you can just take a deposition in every case. Well, in Florida, in criminal misdemeanor cases, you don't automatically get a right to a deposition. So sometimes if you want a deposition, you have to file a motion with the court. Well, here in Idaho, depositions in general at any time after the filing of the complaint, indictment, or information. So this motion could be something as simple as one side or the other wants to take a deposition and they want to do it before the preliminary hearing. That timing is not necessarily proper under the rules, so they have to file a motion with it. If the other side fights it, then the court is going to have to make a call. So something as simple as that, just for you to get an idea. As to stuff that seems commonplace in other cases, because of the timing of where we're at, and it's a little unusual to have this much time between the arrest and the preliminary hearing, that's something that could happen. Okay, Brittany, I see your comment, and we'll get to it here. Yes, but it was the BF interview was agreed to and ruled on by a Nevada court, not by this court in Idaho. So that's just something interesting that it could happen. And maybe the defense wants to file a motion for a deposition since they're going to take that interview. They might want to have it actually be more than just an interview and something taken under oath that can be recognized as a deposition in this case. That's something that could potentially happen with something we know is going to happen with the interview with Bethany Funk. All right, here's another option that I heard people talking about. Something could have to do with the destruction of 1122 Kings Road that the University of Idaho has been making some complaints about how much it's costing to keep it up, keep it going. They want to demolish it and work through that process. If one side or the other or both sides have an issue with that, that is something that maybe the court will have to step in and make a decision. What's going to happen with that? We could also have something like a motion to continue the preliminary hearing. It could be a joint motion, which the court would probably just rule on, or it could be one side objecting to the other side wanting to continue this preliminary hearing. In that case, the court would have to rule on that. Okay? And lastly, and this is what I'm not saying, okay? And this is the difference between using this as an opportunity to learn all the different things that it could possibly be. What I'm not saying is that this means that there's been a grand jury, they've indicted Bryan Kohberger, and this is a motion to get rid of that preliminary hearing. Okay? Is it possible that that's what this is? The answer to that is yes. It is possible that they went the grand jury route instead, and I'm going to bring up some language just so you can kind of get a visual, if you're a visual learner, to see how this is written here. Preliminary hearing in Idaho. And it starts with unless indicted by a grand jury. Okay? And the way lawyers write rules, this is a very, very important phrase because it would mean that if he was indicted by a grand jury, then this would not apply. But if he's not indicted by a grand jury, a defendant charged in a complaint with any felony is entitled to a preliminary hearing. Is entitled to a preliminary hearing means if he wants one, he can get a preliminary hearing. Or if you see later in the rule, the defendant can waive if the defendant waives the preliminary hearing. Okay, so it's the defendant's prerogative. They have a right to, they're entitled to a preliminary hearing, or they can waive it. Unless, you can put this at the end, the defendant has a right to, is entitled to a preliminary hearing. They can waive the preliminary hearing unless they are indicted by a grand jury. So that would mean in this case, if he was indicted by a grand jury, then he would no longer be entitled to a preliminary hearing and they could just cancel the preliminary hearing. Now, if they were going to do that, I don't think they would do it in the form of a motion 4 weeks out. So I think it is very unlikely that this is what's happening. And this is kind of the question I got most through Twitter is this what I think is going to happen? People are hearing rumblings about this, things like that. All right, so I see some questions about the grand jury coming in, so let's hit some of them. Abby, So the grand jury is first. So there might not be a grand jury. So it doesn't necessarily mean that it's first. It can happen first, or they can go this route, get the preliminary hearing, and just have the judge rule on it. Can you explain what a grand jury is? So a grand jury is kind of like a jury trial, except not at all. It is done in secret. The defendant is not there. The defense attorney is not there. The prosecution presents evidence. The grand jury determines what charges to indict a defendant on, in this case, multiple murder counts. And if they feel the prosecutors presented enough evidence, then they just go with that. Brittany says the Gonsalves family attorney announced it was for the gag order. So where did he announce that? If it's a video clip, send it to me. I will try to play it during this live. If it's a tweet, I will try to put it up during this live. Thank you, Gina Tingley, for the super sticker. So this is interesting. Ken says, what if it is a motion to dismiss based on Bethany Funk's testimony? Ken, great question, except it would probably be inappropriate at this point because there's nothing really to dismiss. They haven't brought the formal charges yet. So this would be better had after the preliminary hearing if the judge determined or decides to go forward with the charges on, or allow the state to go forward with the charges against Bryan Kohberger. And you would present Bethany Funk's testimony at the preliminary hearing, hoping the judge would see there's not enough to go forward. So this probably would not be something that would happen right now. It will probably not be the right time in the process. Who is on a grand jury, Kathy asked. It's just like a regular jury. You get picked. Sometimes you're picked for a grand jury. Angel Nikki, welcome to the membership crew. Alyssa, are you planning on streaming the hearing? I probably will not be able to stream the whole thing on my channel. I haven't looked into trying to set that up yet, but I will absolutely be doing nightly recaps, 8:45 p.m. Eastern time. We'll get back into that action that we've done on some big trials. We will do that every single night after the preliminary hearing is over. I may pop on to other people. I may pop on to other people. I'll see if I can copy this somehow. How would I copy this? It's not working. John, are you able to like copy that and send it to me so I can actually click it? So yeah, I will definitely be doing nightly recaps of that. Even if I don't stream it on my channel, I'm sure other people will stream it. Maybe I'll pop on there when I have some time throughout the day. Alley Cat, about the stock trial. I have heard, or I have a form of DID and I have alters. I don't believe stock has it. And if you would want, I'd love to come on a live stream and answer questions and educate on the disorder. So I've actually had some people reach out via Twitter and give me kind of their stories and their impressions. So I would love for you to do that. Our Twitter handle is @TragosLaw. Let me put it right here. If you want to give me some info on it, and then I can kind of present it that way. I think that would be easier than just having one person come on, because I've had a lot of people reach out to me that deal with that or something similar to it. So I appreciate that. Lil Patty, question off topic. Are you going to cover the Mosley case when it comes around? I do not know what the Mosley case is, so I'll need more information on that. Cheryl, thank you. Hold on one second. I'm texting with John here. Thank you for the super sticker. All right, let's see how this works. Oh, okay. We have an actual pleading to look at. This was a pleasant surprise. Shoot, I lost the person that sent it. I think it was Lori Schilling. Thank you, Lori Schilling. Let's take a look at what we got here. All right. So first time looking at this. Let's see if we can figure out what it is. All right. District of Idaho, plaintiff v. Bryan Kohberger defendant. Notice is given. Motion hearing, Gonsalves motion to appeal, amend, and or clarify amended non-dissemination order on 5/25 at 10 a.m. in front of Megan Marshall. Let's see here. Who was it served on? William Thompson, Jeffrey Nye, the AG's office, Ingrid at the AG's office, Casey Government, Shannon Gray at Gray Law. Okay, so I don't see any media members on here. I don't see any media members' attorneys on here. This was filed on 4/28, by the way. I would have thought the media would be involved here since they were the ones that went up to the Supreme Court, and they were the ones the Supreme Court told them, can you please go back to the original court here in front of Judge Marshall? So I would have thought that they would also be on this pleading. I would have thought they would join Shannon Gray here in asking the court. Oh, it just is up now. So it's up on the Idaho. Now it is up on the docket as well. Okay, cool. Well, I'm glad we got this, right? It's a good time for it. So yeah, so it's Shannon Gray, motion to appeal, amend, and or clarify the amended non-dissemination order, which is kind of cool. Perfect timing for our podcast to come out talking about gag orders. We will see if they amend it. And if they do, we will do a video on here. So this makes sense. This makes the most sense as to what's going to happen. And the thought exercise of what other possible hearings it could be and what other motions it could possibly be on, I think is an important one, because if another hearing comes up, you'll already know. Could it be something to deal with discovery? If it's a motion to compel or a motion for a deposition or something like that, you can expect to see it in the docket. Okay. If it's something that, I know they're not technically third parties because they're also victims, but kind of they are third parties in these cases. They're interested witnesses and victims. But if it's something filed like this and they get on the docket for a hearing with this judge, then it may look something more like this, so that And now you know why you have a hearing, because somebody's disagreeing about something. It's not just something simple. There probably won't be a hearing if they cancel the preliminary hearing because they do a grand jury indictment. Probably won't need to have a hearing for that, right? So you can know and understand what we're looking at if something else pops up in the future. And that's why I think the thought exercise is important. So I'm going to leave this up here so anybody that's just jumping into the stream now can see we have our answer of what this May 25th, 10 a.m. hearing is going to be. And it is the Gonsalves motion to appeal the amended and or clarify the amended non-dissemination order. So what do I expect to happen from here? I think that they have also read the Supreme Court's order. And Shannon Gray is probably thinking, I'm going to make that argument, or at least some of that argument, to this judge, that this is too vague, that it is too restrictive, that it should not come into play with the family attorneys, and we should be able to speak to the media. And I would like for that clarification to be written in so that I don't have any issues with any ethics departments, with any bars, so that I can speak on behalf of my clients. Myra, hi, Peter. I've been a part of the Rewatch crew the past few weeks, but I am watching. Thank you for the updates. These trials are hard. They are miserable, Myra. I talk about it with John every time. I'm like, we're going to do Valo today. It's going to be tough. We're going to do stock today. It's going to be tough. I'm looking for angles where I don't have to talk about, the facts of what happened to these kids. I do everything I can to talk about it from like a mental health perspective or, some other kind of legal perspective. I couldn't agree with you more that these are really tough watches. That's why I couldn't possibly do them every day. I'm trying to do them just once a week because it turns into 2 days a week on these kinds of cases. So it's been tough. So please, something that's really helpful to me, and this is something I will ask you for, the greatest channel on YouTube, greatest chat on YouTube, I should say. Bring me questions. It's so helpful on Twitter and Instagram when you ask me questions about specific testimony in the Stalk case or some specific fact in the Lori Vallow case or something the lawyer did or something the judge said. When you bring me a specific question like that, it helps me zone in, say, this is what they want to hear. Let's give them a lawyer's perspective, prosecution side, defense side, judge side. What's everybody thinking? What are we doing? It makes it so much easier for me to listen with a focused intent as opposed to I try to zone out when they're talking about a lot of the facts in some of these cases, which I'm sure you do too. I got to deal with them in my own cases. Taking on too many of them at the same time is just something I'm not really interested in. We have multiple wrongful death civil cases that we're dealing with right now. Some of them kids, some of them adults. They're brutal. They're brutal. They're part of work. They're part of life. I understand they happen and we're still explaining the legal processes of them. But I always, me and my wife have these conversations sometimes where she'll read these books that are like the most sad, depressing books in the world. And then she'll want to tell me about them. Thank you, Kathy. And I'm like, listen, you chose to read that book, not me. I don't want to hear about that. The kid that has terminal illness and is like the best kid in the world and how the mom deals with it. I'm like, Are you trying to cry? Like, do you want to cry tonight? Is that what's happening? So I don't like to do a lot of that stuff for enjoyment. So I like to listen with a purpose. And when you guys tell me you have a specific question or want to know why something happened, that's my favorite way to go into a video on Stalk or Valo, or this Idaho case or whatever it may be. These are the more interesting topics where we can talk about it legally and don't have to talk. I know there will be a time to talk about the facts, no doubt, but not every day. Christina, why wouldn't they go with a grand jury? That way Funk's testimony is not presented. I don't think they're trying to like hide Funk's testimony. They know it's going to come out eventually. And there are risks when you go to the grand jury, just like there's risks when you go to the preliminary hearing. I will tell you, very, very few and far between does the defense win a preliminary hearing. You have a judge, which is more likely to find probable cause and let the case go forward. A grand jury, now listen, very, 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 very high percentage of the time, the prosecution gets the indictment they want at the grand jury. But number one, it is a jury, right? You never know what people are going to do. Think about the Nicholas Cruz case. They surprised us all. And a lot of us disagree with what they did, but they're a jury and it's their prerogative and they're part of the system. So there is a risk when a jury is involved. Number two, if there are issues that happen in the grand jury proceedings that defense doesn't know about until later, well, like the Murdaugh case, those can become major issues at the trial. So it's kind of like a strategy decision. Sometimes it can take longer to get a grand jury together. Sometimes it can take shorter. This is just the decision they made in this case. TMIM, dumb question. He had not been formally charged. On what grounds are they keeping him in jail? So they have probable cause to keep him in jail. Probable cause for his arrest, and the no bond has, his safety of the community, likelihood that he would flee. I'm not saying that he did flee, but he did drive across the country basically to go to his house. Not like he was really hiding, but they go through the balancing act of holding somebody just as if they were formally charged once they're arrested. And he agreed to this preliminary hearing date. He could have demanded it happen. I can't remember what the actual time is, but there is a speedy preliminary hearing time, like similar to a speedy trial time. He did not demand that speedy preliminary hearing, and therefore he's going to sit in prison. Azam, Peter, what is the consequence if there is no preliminary hearing? It would just mean they indicted him through a grand jury. Linz, hi, curious to know what you're most interested in finding out in June with BK. I'm interested in finding out what the victims and the witnesses that were there, what they saw, what they heard, what happened between 4 a.m. and 12 p.m. I'm interested to know what other DNA evidence they have, if any. I'm interested to know what they found at his house and what they found on his computers and what they found on his cell phones. What searches did they find? Did they find how to get rid of a knife? Did they find anything like that? I mean, as crazy as that Walsh situation was, where he Googled how to get rid of a dead body or whatever, like that literally happens. So I'm interested to hear if that happened in this case. Did they find on his computer that he was writing a book about committing this crime? Is there something like that? Because I think that could be as damning as a smoking gun in this case, as finding the knife in this case, because of what we know about his background and his schooling. So I'm interested to just see what evidence they have. Joe, how hard is it for the prosecution to prove Lori Daybell had a hand at hurting her children? And do you think she is a manipulator? I definitely think she's a manipulator. I think Chad Daybell is a manipulator as well. We'll save some of this for when we actually do the Lori Vallow video. But I don't think they have to prove she actually had a hand in there that day, but she had a hand in the planning and the partaking in what happened. But it sounds like they may have actually found some DNA evidence or physical evidence that she was actually physically there taking part in this. More on that later. Ohana means family. Just a few days ago, they said he could be exculpated. Now they're having an early court hearing then planned. Are these not related? So it seems like the answer is no. This court hearing on May 25th is about the gag order. The Gonsalves family, one of the victims' families, they filed a motion to appeal. I can put it back here up on the screen, to appeal, amend, and or clarify the amended non-dissemination order. So this does not have anything to do with the potentially exculpatory evidence of Bethany Funk or anything that's exculpatory or anything with them going with the grand jury indictment instead of a preliminary hearing. Thank you, Azam, for the super sticker. All right. If you have any other questions, get them in now. I want to remind everybody that when we deal with cases like this, there are a lot of difficult portions of it. And we don't ever want to be callous or cold toward the victims in the case, especially when we talk about exculpatory evidence or potentially exculpatory evidence or alibis or things like that. We are just looking at it from a legal perspective. We are looking at it as a criminal defendant who is accused and who is presumed innocent. And that's really how we look at these cases, as gruesome as they are, including Lori Vallow and Letitia Stalk. When the trial started, they were presumed innocent. Now, as we have all together listened to a lot of evidence be stacked up against them, it is 100% fine for us to feel that they have committed those crimes beyond a reasonable doubt. Now, we wait to make up our mind fully until the trial's over, but as we hear evidence stack up, that's how we look at these cases. And with Bryan Kohberger, zero evidence has been presented in a court of law. Now, we're going to hear some stuff at the preliminary hearing, and even then, the rules are not necessarily the same. Some of that evidence may be deemed inadmissible. I also heard some people asking if it's a motion to suppress. There wouldn't really be a motion to suppress at this point. That's something that would be handled at the preliminary hearing or even after the preliminary hearing, especially if it's a big piece of evidence. They used the preliminary hearing and then they found out it was gotten by a legal cause, and then they try to suppress it later. That's stuff that would happen later. I would not expect that to happen before the preliminary hearing. My question is, why did the court change the date for the preliminary hearing to 6:30? I didn't see that. I thought it was 6:26 to 6:30. I thought it was that whole week. I haven't seen them changing that. I haven't seen them change that date. Miri, do you think Miss Funky, I think she meant Funk, not wanting to return to Idaho could mean the real murderer was not arrested? I am not going to say that. I think it means she doesn't want to be involved. She doesn't want to talk about this case. She doesn't want to relive it. She wants to mourn and move on and probably deal with some PTSD. And she just does not want to be involved in this case. No, she does not mean anything ill will towards the other victims or anybody that was involved in this. Every person deals with this situation differently and how it affected them. And I would not blame her at all for that, for not just being like, okay, yes, I can't wait to come testify. And not that there's anything wrong with somebody who does want to come testify and help get justice, right? But I think the fact that she doesn't want to go back to Idaho or that she doesn't want to testify at the preliminary hearing is not abnormal for a 20-something-year-old girl who's been through a traumatic event. Christy, Peter, do you think that BF was totally wasted or on drugs? Why would she wait so long to call people? Who goes to sleep after hiding from an intruder in your house at 4 a.m.? I don't know. Some of these things I hope are answered at the preliminary hearing. Welcome, Joe. Alley Cat, can I email you about DID instead of Twitter? I stay away from Twitter? Sure. LawyerYouKnow@gmail.com. Absolutely. Barbara G. Does the prosecution have to lay out everything they have against PK? No. They don't have to lay out everything. They have to lay out enough for the court to find enough cause to allow them to go forward on the murder charges. Now, probably don't want to take any chances, because if you do the preliminary hearing and you lose, that's a bad sign. Now, you can theoretically, there are different ways you could do. You can have another preliminary hearing. You can go for a grand jury indictment still. So they don't really hold back a ton, but they don't put everything out the way that they would put it out at trial. Jay-Z, did you enjoy the NFL draft? I did. I love the NFL draft. It's one of my favorite sporting events of the entire year. Did you enjoy, any S? I don't know what any S means. Any surprises maybe? I did think there were some surprises. Will Levis fell way further than I thought that he would. I thought there were some reaches. I thought some running backs went earlier than a lot of people expected. But overall, fun draft. And now my fantasy football leagues are starting to do their rookie mock draft or rookie drafts in those leagues. So that's fun. And, football just never ends. Abby, wouldn't a grand jury make sense? More sense than a preliminary hearing? Can you interview jurors after a grand jury trial? You'd think they'd want to get some feedback for jurors. So no, it's all done in secret. Defense doesn't get to question the jurors. Defense doesn't even get to be there. They don't know anything that's going to happen. I mean, what makes more sense? It's up to the prosecutor in a given case. Miri, do you think, sorry, we already answered that one. Veronica, thank you for the super sticker. All right. What happens if a grand jury doesn't indict? Then they can't bring those charges against the defendant. All right. I think we have hit all your questions. I think we have gone over all this. Just in case you're just jumping on now and you didn't rewatch the whole thing, We'll end the video again. We know the answer that we asked in the beginning. What is the motion hearing on May 25th? Well, it is a motion hearing filed by the Gonsalves family to appeal, amend, and or clarify the amended non-dissemination order. Nobody on the media teams, lawyer-wise, media members that was on that writ filed up to the Idaho Supreme Court. None of them are on here. They're not on the service list. It doesn't seem like they're involved in this motion hearing. It doesn't seem like they were even notified or they're going to come and argue for the media team. That might be something separately that happens. But as it sits right now, it's the Gonsalves family that wants some clarification on this non-dissemination order, even the amended one. All right. I appreciate everybody jumping in to this live. Hopefully you guys can join us later in the week for the Lori Vallow live and update and the Letitia Stalk live. Hit that like button if you haven't already, and please subscribe. Help us push towards 250,000 subscribers. Appreciate everybody joining us as always. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a know you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.